Dear students, welcome back. In this class, we will be starting with the first compliance under the subject corporate compliance. After discussing about the introduction to the corporate compliance, followed by the first and foremost very important act under this as the Companies Act of 1956, where we discussed what is this Companies Act of 1956. No, so with all this the basic information, let us move to the important complaints under this act. The first important complaints or legislation is the Indian Contract Act of 1872. So now let us try to understand why we are discussing this as a very important legislation under this subject. So the reason is, so before we start or when we start functioning as a company, then we'll be into different functions or processes. The one such important process is the contract, where we try to usually make a contract with many people, like maybe different vendors or the outsourcing people, say for example to procure the raw materials, no, will be depending on many vendors. So that time we go for some contract, no. So what type of material, what should be the quality, and how frequently they have to send, what is the price of that, so what is that condition, so that we make a contract with such vendors, so that the process, your functioning will be smooth, and there should not be any disturbance in between the process, because once the production starts, again no, whatever has been set as the production cycle, it has to continue. So any kind of the has any kind of some obstacle in between, no, definitely it will hamper the smooth functioning of the business. So in that regard, we will be discussing about the Indian Contract Act. So what are the different the conditions, no, that has to be followed when we will be into the contract with different people, maybe with the employees while hiring, maybe while hiring some workers, or when you go for an MOU with some delegates, with the international business, like that. So some necessary contract will be making. So we will be discussing here about the meaning of contract, then agreement, essential elements of a contract. Again here we will be discussing about different types of contract and law of agency, then creation, termination of agency, then some important terminologies as bailment and pledge, then rights and duties of the bailer or bailee. So now let us understand what is the law of contract means. The law relating to the contracts is to be found in the Indian Contract Act of 1872. So it says that it is different from other branches of law in every important aspect. So that is, it does not lay down so many precise rights and duties which the law will protect and enforce, because it contains a number of limiting principles which is subjected to the parties, where in they may create rights and duties for themselves, and the law will uphold those rights and duties. So in case if you limit, no, in order to control or supervise the transaction, we this the conditions or laws will enforce into in this. So now let us understand what is this business law before we proceed with the Indian Contract Act. So business law means, as we all know, businesses interact in many and varied ways. So the any law that governs the such businesses we call as business law. Now coming to the next important terminology, that is contract. According to section 2H, a contract is defined as an agreement enforceable before a law. Means whenever we are into the process of agreement, we come across the word called as contract. In order to enable that agreement, we need to undergo a process called as an contract. Means this contract and agreement, they go hand in hand. And coming to the next terminology, that is agreement. According to section 2E, every promise or set of promises forming a consideration for each other, that we call as agreement. Now let us understand then what is a promise. Promise means, according to section 2B, when a person made a proposal to another to whom proposal is made, if proposal is very much required, then it is called as a promise, where you ensure, you promise, you propose that you provide, you supply, then it is called as a promise. So these are the very important terminologies we come across in this act. That is, because of a promise we go for an agreement, because of an agreement we end up with a contract. So that is, for example, the good example is between a vendor, a supplier, and the entrepreneur or a business owner. Where you make, he will be promised to supply particular the set of the required things to the enterprise. Now let us understand what are the essential elements of a valid contract. Because a contract too said as a valid, because when a contract is valid, then only all these the laws will govern, or that comes under the Indian Contract Act. Where if it is not valid, then there is no need to, means where the legally there is no provision to claim, or the legal where we cannot reinforce under the legal claims. A contract consists of two elements, that is an agreement or a legal obligation, that is it should enforce at the law. However, there are some agreements which are not enforceable in a law of court. Such agreements do not give rise to contractual obligations and are not called as contracts. The essential elements of a valid contract can be summed up as the follows. The first one is an agreement, then intention to create a legal relationship, and free and genuine consent, parties competent to contract, then lawful consideration, lawful object, agreements not declared void or illegal, then certainly of meaning, then possibility of performance, then necessary legal formalities. So these are the essential elements of a valid contract. Then the next important terminology is law of agency. It means a agency is created when a person or company that we call as agent agrees to act for or in place of another person or company, that is a principal. So if we have some the mediator in between who can act between a person and a company, that we call as agency, or that person is called as an agent. Here we have certain laws to govern that agency, that is the principal, means the company creates authority in an agent, then the agent receives authority and carries out the principal's instructions, then third parties make a contract or are involved in the tort with the agent. So ultimately the result will be the principal is bound by the agent's act with a third party. So then we discuss about classification of agents. Means the different types of agents we have, then how to create an agency, that is agreement of parties, then agency by estoppel, then implied or express, then agent's authority to act for the principal, that is for the company. In case of any violations, then it will definitely attract some fine. So what are the the duties of the agents that to be followed? So that means like loyalty, obedience, reasonable care and skill, like that. Then the another important terminology we come across here is the bailment. Bailment means it is another type of special contract. Since it is a contract, naturally all basic requirements of contract are applicable here. A bailment is the delivery of goods by one person to the another for some purpose upon a contract that they shall know when the purpose is accomplished be returned or otherwise disposed of according to the directions of the person delivering them. So it means an act delivering goods for a specified purpose on trust. Means when some agreement has been made, the a special contract, no, so we usually will be there, we make in a transaction, so that is called as bailment, where you will be liable to supply certain goods, no, so for certain period, so that is called as bailment. But in this case the ownership is not transferred, so the still you will be like considered as an agent, no, where you will be supplying certain required goods under the transaction or under the said agreement. And here we have the essentials of the bailment and classifications of bailment, then rights to bailer, then duties of bailer, rights of bailee. A person, no, who takes up that bailee or bailment is called as bailee. Then duties of bailee, then particular no, lien and the general lien, so that has to be followed. So this is about the Indian Contract Act. So this follows the next important act, that is Consumer Protection Act, because once we understand what is an Indian Contract Act, then coming into it's the related area, that is where that contract usually will be between the vendor and the company, where they with that the agreement they try to manufacture the goods required, and that will be sold to the customers or consumers. So in that case where there is some transaction as the sales of goods or the buying of goods, then consumer there will be some issues with the sales and there will be some issues with respect to selling and buying. There we discuss about the Consumer Protection Act. This act was enacted by the Parliament in 1986, which provide better protection of interest of the customers, and it also helps to make provisions for the establishment of the consumer councils and other authorities for the settlement of consumer disputes. Now before we proceed, let us understand who is a consumer. Consumer is one who buys any goods for a consideration and includes a hire or purchaser, or any user of such goods for consideration but excludes one who obtains for resale or for commercial purposes. And also it helps to hire a service for consideration and includes a beneficiary of such service if availed of with the approval of the hirer. Now let us understand what is a defect. A defect means, so usually in this Consumer Protection Act, the dispute will be with respect to the quality or quantity concerned issues. So now let us try to understand what is a defect is. A defect is a fault or imperfection or shortcoming, no, that we come across with respect to quality, quantity or potency or purity or standards of the product.